All right. So today we have the fourth and final installment of our personnel data webinar series with the Data Practices Office. Thanks for joining us, everybody. If you'd like to download a copy of today's PowerPoint, I'm going to share the file now. I know this doesn't work for everyone. The PowerPoint's also available on our website on the webinar page where you registered for this. If you scroll all the way to the bottom and you go to Government Data Personnel Series, I believe it's called. This one is the fourth one in that installment. Okay, it should be appearing on your screen now. Like I said, I know this doesn't work for everyone, so if you are not able to download the slides, they are also on our webinars webpage. If you've been watching our webinars, you'll have heard a bit about our office already, but if you're just joining now, our office is a resource on all things data practices and the open meeting law. Most of what we do is answer questions about these laws from members of the public and from government entities. We also provide training on different data practices and open meeting law topics, and today is our final webinar in our personnel data webinar series. We also record all of our webinars and post them on our YouTube page. To view those recordings, if you go to our website, we have a YouTube icon at the bottom of our page that you can click on, and that'll take you straight to our YouTube page. Or if you go over to our resources tab in training materials, we also have links to some videos on there as well. Okay, I'm going to close up the file. So this is today's agenda. We're going to start with a recap of the personnel data series that we've had so far, and then we're going to go into frequently asked questions that we receive regarding personnel data. As usual, we'll have time for Q&A at the end. So as you think of them, or you can save them up until the end if you choose, type those questions into the Q&A panel and send them to all panelists so we can be sure to see them. And if we don't have time to get to your question today, we will be following up after the webinar. Just a reminder that parts 1 through 3 of our personnel data series webinar are already available on our YouTube page. These are our links here. And as I said, you can find that also by going to our website and clicking on the YouTube icon at the bottom of the page. All right, let's jump into our recap. So our first webinar was an introduction to personnel data. The Data Practices Act presumes that all government data are public unless classified otherwise. However, the Personnel Data section 13.43, reverses this public presumption, and it states that all personnel data are private unless specifically listed as public. Personnel data are government data on individuals maintained because the individual is or was a government employee or an applicant for employment, volunteer, or independent contractor with a government entity. Subdivision 2 lists out what is public data for government employees, volunteers, and independent contractors, and Subdivision 3 lists public data on applicants. We also discussed the difference between personal data and personnel data. The Commissioner addressed this distinction in Advisory Opinion 01-075. As a reminder, the advisory opinions are available on our website, and you can search by number or topic. So if you want to read that opinion, feel free to check it out. Personal data are not government data because the employee did not create the data in their capacity as a government employee, and the purpose of the data is not related to the operation of government. Therefore, personal data are not subject to the Data Practices Act. However, what will actually be classified as personal data will depend on an entity's incidental use policy. Lastly, we noted that government entities must make the determination as to whether elected officials are employees. If they are employees, then data about them will be classified under 13.43. But if they're not employees, the data about elected officials are presumptively public, with the exception of correspondence, which is classified by 13.601. And that's correspondence with members of the public. Entities should memorialize this decision as to whether elected officials are employees in some way so that both the public and the elected officials know what to expect in terms of how data about elected officials will be classified at the entity. Moving right along to our second webinar. In our second webinar, we focused on sharing personnel data. We noted that public data can be provided to any person or entity for any reason, and requesters do not need to justify their request for public data. And you can share public data without needing specific authorization or justification for doing so. But non-public or private data, such as private personnel data, may only be shared with those within the government entity whose work assignment reasonably requires access, or other entities or individuals that are authorized to access the data by statute or federal law, and entities or individuals who are given access by the data subject through informed consent. Next, we discuss the requirements of Tennyson warnings and informed consent. Tennyson warnings are the notices provided to data subjects before a government entity collects private or confidential data from them, while informed consent is provided after a government entity already has the data and either wants to use the data in a different way or share it with a new recipient, or the data subject wants to authorize someone else to access their private data. You also need to get their informed consent to share data in that way. The language in your Tennyson warnings can limit your ability to share private data because the authorized use of the data you collected is limited to the purpose and intended use stated in your Tennyson warning. An entity can get an individual's informed consent in order to use the data in a way that is not set out in the Tennyson warning. We also discussed that when collecting social security numbers, government entities have additional requirements under federal law to comply with. Further, under Minnesota Statutes Section 13.05, Subdivision 3, government entities should not be collecting and storing data on individuals unless it is necessary for administration and management of programs authorized by law. So given the requirements around the collection of social security numbers, we really encourage entities to consider whether they need the social security numbers for the administration and management of their programs. If you don't need these numbers, you shouldn't be collecting them. We then highlighted the statutory sharing for unions has been updated under Section 13.43 Subdivision 6. This subdivision has broad language that requires entities to share data regardless of how the data is classified, to the extent that the data is necessary for the union to conduct elections, investigate and process grievances, and implement the provisions of Chapters 179 and 179A. We noted that subdivisions 11, 12, and 15 of Section 13.43 set out situations in which an entity may share personnel data with law enforcement. Lastly, we discussed what we call the traveling data provision, which is set out in Section 13.03, Subdivision 4. This provision states that when a government entity shares data with another entity, the data will either maintain the same classification at the entity receiving the data as the entity providing the data, or if the entity that is receiving the data has its own classification for the data, the classification shall change to that classification at the receiving entity. So this situation can result in scenarios where the same data are classified differently at different entities. So it's really important when you are sharing data to be aware of what classifications will apply. Then we went along to webinar number 3, where we focused on complaint and discipline data. We also spoke about settlement agreements a bit in this webinar. For complaint data, the existence and status of a complaint or charges against an employee are always public. You can disclose if there is a complaint, how many complaints there are, and the status of the complaint or complaints. We suggested reviewing the case Navarre versus South Washington Schools, which is a Minnesota Supreme Court case that gave examples of what type of language goes beyond existence and status when speaking about a complaint. The court said that statements that describe the quality or characteristic, nature and character, or severity of a complaint goes beyond existence and status. While a complaint is pending, all other related data are private. So employees still have access rights while the investigation is pending. In some instances, some of the data may be confidential civil investigative data under 13.39, but that section requires a pending civil legal action, and the chief attorney for the entity determines whether there is a pending civil legal action. So for most complaint investigations, this probably won't apply and the data will be private. Next, we discussed what additional information about the complaint or charge becomes public um, will depend on whether the employee received discipline or whether the employee is a public official. So this is after the complaint has been processed. For regular employees, when an investigation into the complaint does not result in discipline, all the investigative data remain private. Only the existence and status are public. And so your statement could be as simple as there was a complaint and now it is closed. If there is a final disposition of disciplinary action, then the disciplinary action, the specific reasons for the action, and the data documenting the basis of the action become public. For state level public officials, upon completion of an investigation, or if the public official resigns or is terminated while the complaint or charge is pending, all data related to the complaint or charge become public, except for private data on other employees. For local level public officials, all data become public if the complaint or charge results in discipline, or if the public official resigns or is terminated while the complaint or charge is pending, or the public official settles with the entity and releases the entity from liability related to the conduct. Lastly, we talked about settlement agreements. The complete terms of an agreement settling a dispute arising out of the employment relationship are public. If the settlement agreement involves a payment of more than $10,000, then the specific reasons for the settlement agreement are also public. All right, we're going to go ahead and jump into our frequently asked questions. First up, we have, can an entity post all upcoming employee resignations and retirements prior to the employee's last day? The answer is it depends. Data are private. So the question is, who are you sharing it with and why? Data about resignations and retirements, the reason why someone is ending their employment, are private data because they are not one of the public data elements that are listed in subdivision 2 of section 13.43. Similarly, data about an employee's anticipated last day is not public. We don't know for sure that an anticipated last day will actually be the employee's last day. The employee's last day needs to have actually occurred for the data to be public under subdivision 2. That said, you can share private data within your entity if there's a work assignment. So if the supervisor determines that other employees need to know that someone is retiring to prepare for the transition or to transfer knowledge from that employee, then the data about a planned retirement could be shared with those employees. Another scenario is you might have consent from the employee who's planning on retiring. They may want to let people know where they're going and what their plan is. So if they give you their informed consent to share that information, you can do that as well. If you don't have a work assignment and you don't have the employee's informed consent, then you really need to do a risk assessment as to whether you can share that private data. Question number 2. Is leave that is coded as FMLA or PFML public data? The answer here is probably. This is probably part of the public data element under subdivision 2, but to some extent it will depend on the coding that an entity uses. There are a lot of reasons why a person could take FMLA or PFML leave, so just a general code would not reveal the employee's reasons for the use of sick or medical leave. However, if an entity has very detailed codes that somehow reveal the reason for the use of that FMLA or PFML sick time, that data would likely be private. So you're really going to need to take a look at the codes and see if they're general or if they reveal more about the employee's use of that leave. Question 3. For employees who work fully or partially remotely from home, is their home address public as work location? The answer is no. The work location data element under subdivision 2 is general, and so that's really satisfied by providing the primary government office where the employee can receive mail. Question 4 is related. How are personal cell phone numbers of employees classified when employees use their personal cell phones for government work? Generally, these numbers are private. Under Section 13.43, Subdivision 2, it says that a work telephone number is public data. It doesn't require that all telephone numbers used for work purposes be public. So, an employee's public work phone number can be a direct or general office number, and the employee's cell phone number would remain private. That said, the employee could provide written informed consent for the entity to share a personal phone number that is used for work purposes, or the employee might choose to share their own personal number directly when necessary or appropriate. Because it's their private data, they can choose to share that information. Question 5. Must confidential civil investigative data be provided to the union under Section 13.43, Subdivision 6? The answer is yes. To the extent that personnel data has been pulled into a civil investigation, that data still needs to be provided under the language in Subdivision 6. Subdivision 6 starts out by saying, notwithstanding classification by any other provision in this chapter. That language was added with this specific type of data in mind. Government entities cannot use 13.39, the civil investigative data section, to withhold personnel data from unions. I know our guidance on this section may differ from other guidance you have received, but our guidance is based on the plain language of the statute, as well as legislative discussions around this new language. Additionally, just note that Subdivision 6D exempts an employer who disseminates personnel data to a labor organization pursuant to this subdivision from liability under Section 13.08 for disclosing non-public data. So there is language there to protect the employer who is relying on Subdivision 6 to share non-public data with unions. Question 6. Does the employee who is the subject of the complaint get access to data identifying the complainant and any witnesses? This is another it depends. It's going to depend if the complainants or witnesses are public employees. The names and addresses of complainants are data about the complainants, and identities of complainants or witnesses who are members of the public are generally presumptively public because there's not a statute that classifies them otherwise. Therefore, if the complainants or witnesses are members of the public, the subject of the complaint would get access to this data. However, when the complainant or witness is a public employee, we have Section 13.43, Subdivision 4, that classifies their identity as private personnel data. That's because it's not listed as one of the public elements in Subdivision 2. So, if the complainant or witness is a public employee, the subject of the complaint would not get access to the data that identifies these complainants or witnesses. I also want to note that there are some extra protections available when the complaint involves harassment. Subdivision 8 of Section 13.43 states that an employee will not have access to data that identify complaints or witnesses for these type of allegations if the responsible authority makes certain determinations. However, if a disciplinary proceeding is initiated against the employee, data on the complainant or witness shall be available to the employee as may be necessary for the employee to prepare for the proceeding. So at the initial harassment complaint stage, if a determination is made that the identity of the complainant or witness needs to be protected, it can be if those determinations are made. But later, if there is discipline, some information will become available for the employee to prepare for that disciplinary proceeding. Question 7. After there has been a final disposition of discipline, the employee who was disciplined asks for the file related to the complaint. What data do they get? So there's no confidential classification for personnel data. That means that the complaint file will likely contain public data and private data. And the employee will get access to public data and private data about themselves. So to the extent that the file has private data on other employees, that data would be redacted, but otherwise the file will contain public data and private data on the employee, and that should be provided to the employee. So in most cases, they will have, or maybe not most cases, but much of the file will be accessible to that employee. Question 8. Can a government entity disclose whether an employee is on paid or unpaid leave related to complaints against that employee? The answer is not while a complaint is pending or if there has been no discipline. On leave with pay and on leave or suspended without pay may be forms of discipline. So these statements should not be made if there has not been a final disposition of discipline. Until there has been that final disposition of discipline, the only information that is public related to the complaint is the existence and status. Data requesters could potentially determine whether a government entity is or is not paying an employee by requesting other data, like payroll data. But payroll data would not be disclosing that paid or unpaid leave is related to a complaint or charge. So that's sort of showing you that there are ways that someone could figure this out. That doesn't mean that you would withhold other public data, but when you're talking about the status of a complaint, you wouldn't reveal that information in connection with the status of the complaint. Advisory Opinion 04-047 discusses this on leave with or without pay distinction in greater detail. So if you're interested in that distinction, I suggest checking that out. Again, that's Advisory Opinion 04-047. Okay, I'm a little ahead of schedule, but we are going to take your questions now. I think some people have perhaps already started typing their questions into the Q&A panel. If you haven't and you've thought of one along the way, please feel free to put that in the Q&A panel now. Make sure you send your questions to all panelists. And like I said, if we don't get to your question, we will follow up afterwards. And the slides are available on our website on the webinars page. And we're also going to have a recording of this webinar up on our YouTube within a day or two. And in just a second, I will be starting a poll in the polling panel. If you could please fill out that evaluation so we know how we did and we can continue to improve these webinars, that'd be greatly appreciated.
All right, I am happy to start with the first question here. And just as a reminder, if you don't hear us speaking or there's just some silence, your computers are probably still working. We're just looking through the various questions and getting answers ready. Okay, so the first question we have, where is the best location to store personnel data related to performance evaluations or performance reviews, et cetera? You know, those types of data that supervisors might have about their employees? This is a really good question. There's not a one size fits all answer here, and so there's not a single right answer to this question. There's plenty of wrong answers to this question, like leaving private personnel data out on top of your desk or leaving it on the kitchen table at home if you are working from home. That's the wrong answer. You shouldn't be leaving private personnel data out like that. But when it comes to where the best location to store that is, it's really going to be up to each government entity. Generally, Section 13.05, Subdivision 5, talks about the responsible authority or government entities establishing appropriate security safeguards for records containing data on individuals that are not public, and ensuring that only individuals who have work assignment or employees who have work assignment can access those private or confidential data. And so it's really going to be up to your government entity to determine what is the best location to store those data. Best practices, probably ensuring that any physical paper documents are in locked cabinets or in some way that's not accessible to the general public, or might be come upon by cleaning staff or anyone else in that matter. So storing physical records in locked filing cabinets or those types of things. When it comes to digital data, ensuring that you've got appropriate security protocols in place, things like security access, passwords to open lock documents, or storing individuals' personnel files in files on a shared drive where only certain individuals who would have access to that or require some sort of security permissions. And so it really is going to be up to each entity on how it's going to specifically work through those processes. And so this would be a great question for HR staff, teaming up with the data practices staff if you're a larger agency, and talking about what those best procedures are on that front. And so again, you'll need to have the data secure. How that's done is going to vary a little bit from entity to entity, but yeah, making sure that you have some of those security procedures in place is the important aspect.
All right, I am happy to jump in with the next question. So the next question asks, is key card data, like when an employee keyed in or keyed out of an office, private data on employees? If it's private, is the key card info available to county commissioners? So I'll start with the first question as to whether this key card data is private data on employees. I would ask, in this conversation about the data, how are you maintaining this data? Why are you maintaining this data? Personnel data are defined as, data that a government entity is retaining on an individual because they were, is, they are, were a government employee, volunteer, or independent contractor. So are you maintaining this data on the employees? Are you maintaining it because it's data about one of your buildings or one of your entrances? I think that will impact whether or not you consider it personnel data on your employees. If you're maintaining it, let's say, the Department of Administration keeps a log of every time I'm using my key card in and out of the building, and they can look it up by my name, my employee number. I would say that probably is personnel data on me as an employee. It's being maintained because I'm an employee. It's being organized and searched for through my employee identification. And because of that, it is private because it's not explicitly classified as public in Minnesota statutes 13.43. So if it is personnel data, it would get that private classification because again, we have that private presumption for personnel data. It's not explicitly called out as public. So if this sounds like your data, how you're maintaining this data, what it's looking like for you and its personnel data, it is going to be private. And that leads to the next question, which is the key card info available to county commissioners? Or if you're not in a county, maybe city council members or what have you. So if, let's say in this example, the county is maintaining key card information on its employees, by its employees, because they're employees, that's going to be private personnel data. Can a county commissioner get access to it? Well, private personnel data may be shared within a government entity if there is a work assignment. So I would say for access to the county commissioners, really the responsible authority in charge of this key card data is going to have to make a determination whether or not there is a work assignment for the county commissioners to use to access this private data as part of their work for the county. So the responsible authority would make that determination, and if they determine that the county commissioners do have a need to get access to that private data so that they can do their work, then they could be able to receive that private data as part of that internal sharing. So hopefully that helps. If there's additional information you want to talk about this key card data, feel free to reach out to us and we're happy to have a discussion.
All right. Uh, we're not seeing a lot of questions in the queue right now. So if you have thought of something and you're kind of on the fence if you want to ask, go for it, I say, or you can send it to us later. Um, yeah, any questions about retirement data, complaints and discipline, sharing with unions, um, feel free to put them into the Q&A. We'll hang out for a couple minutes and wait and see if there are more questions. I'll go ahead and go to our next slide. If you decide that you want to send questions to our email directly or give us a call on the phone, this is our contact information as well. If you're logging off, thanks for joining us. And like I said, we'll hang out for a few more minutes and see if we have any other questions.
Another question here, kind of under the deadline. No, we got plenty of time here yet. Okay, and I just am making sure that folks can see this. Does the data that becomes public under 1343 subdivision 2A, paragraph 5, include the whole investigation file or just report and exhibits? Another great question. So I'd say it's not the entire investigative file, right? When you are uh, doing a personnel investigation, I'm sure, I've never done one of these, but I imagine that there's a lot of information that's collected and sorted through and to try and understand what happened. And so there's going to be a broader scope of data that's collected that are related to the investigation than what actually becomes public. And so when you look at 1343 subdivision 2A, paragraph 5, the data that become public once a discipline occurs is the final disposition of any disciplinary action together with the specific reasons for the action and data documenting the basis of the action, excluding any data that would identify confidential sources who are employees of the public body. And so, we're talking about other employee witnesses or complainants on that front. And so, yeah, so it's not the entire investigative file. It's really only those data that are related to the actual discipline itself. So if there's a written reprimand, that letter, with that written reprimand is likely going to be the data that's public. But then the other specific reasons for the action. So why was this individual disciplined? Why was this employee disciplined? There's going to be certain aspects there. Again, not the entire investigative file, and data documenting the basis of the action. And so let's say someone was sending inappropriate emails to coworkers or to members of the public. Some of those emails might be public data to some extent as it relates to that disciplinary action. And so, again, it's not the entire investigative file, but there's not going to be a one-size-fits-all answer here because people are disciplined for different reasons. The data documenting the basis of that discipline is going to be slightly different in each case. And so, one of the things that we do see folks do or government entities do is write up a final summary report, right? And so, in that summary report has the discipline that's occurring as well as, key statements or key information that was collected from the investigation. So it's kind of a nice, tidy summary to the investigation itself and why somebody was disciplined. And so, that may be something to consider doing as part of your personnel investigations. You're not required to create that as part of the Data Practices Act, but it is something that, hey, might give you an easy way when somebody comes and asks for the public data related to that incident. You've got that top level summary report that you can provide as the public data. So again, it's only certain data as part of that investigation. It would not be the entire investigative file.
Okay, we have another question. Let me just mark it here so you can see it. So this question asks, can we post an anticipated job opening after receiving a resignation? We can't share who's leaving without informed consent. So they want to clarify if you can share who is leaving with informed consent or if there's another way to share that information. So just to go back a little bit, when someone resigns, their last date hasn't occurred yet, right? The last date will be public data under 1343 once it occurs, but it hasn't occurred yet. They've resigned. And so this is information about that employee, right? So technically under 13.43 subdivision 4, we're just under this private presumption here that this data about that employee who submitted their resignation, information when they're leaving, that sort of thing, that's all private data about that employee. So you as the government entity have to determine if you can share that information. And in this example, you're posting that job, right? You're trying to get that position filled. You probably maybe want to talk to staff about, hey, this position is opening up. You want to inform them that maybe their colleague is leaving, that sort of thing. So you have to find the avenue to share that private data if you want to do that, because that data are classified as private. So this question asks, you do that with informed consent, right? Yes, that is one of the avenues that you can share this private data about the employee is with their informed consent. So if that employee submits their resignation, you can have a conversation with them, get in writing that they're okay with you sharing certain, elements about their departure. That's a great way to do it, just to make sure that all your ducks are in a row. Excuse me. The other way that you can think about sharing this private information within your entity is think about who has a work assignment, who needs to know this, right? In preparation for, this person's departure. Maybe you have to transition some activities, some responsibilities, that sort of thing. So your entity, your responsible authority, can make a determination that certain individuals at your entity have a work assignment to access this private data. So it's not through informed consent. Your entity can make a determination that there is a work assignment for certain employees to know that this individual is leaving and so on. And that is a determination that your entity can make, and a reasonable one, I think, right? If someone's leaving, there's probably some information that needs to be shared just to plan for their departure and make sure that you can continue providing services. But that is something that you will have to determine in order to share that private data. So just to clarify, informed consent is an avenue to share this private data about the employee who will be departing, as well as you can make a determination as to what employees at your entity have a work assignment to know that private data. That's another way as well.
And I would just jump in here. So sorry, don't mean to step on your answer, Ellen. The other thing that, like, the fact that somebody's leaving doesn't prevent you from posting a job opening, right? You've got your other processes in place, and so certainly folks can maybe infer that, hey, there's a posting for the assistant director of the data practices office. That must mean that Casey is resigning or retiring a long way from now. So maybe people can infer that, but I don't think the 1343 would prohibit your entity from posting a job opening in order to ensure the continuity of services or things like that. You don't have to wait until someone's gone before posting those job openings. And so I think so long as you're not including, hey, you're taking Casey Carmody's job, I think you're probably going to be okay on the posting on that front. It doesn't limit it from that aspect.
I absolutely agree. And please step away. That's great.
Question that is, if an employee chooses to share their personal cell phone number in an email to an outside entity, is that cell phone number now public? Sharing it isn't necessarily going to change its classification. So if a member of the public comes to your entity and says, I want all personal cell phone numbers of your employees, you can reasonably say that's 1343. If you have a data request from a member of the public that would include an email in which they included an employee included their home or personal phone number, you're maintaining it as the maintaining entity, I think it's reasonable that you would go through and take those out as well. The thing you can't control is that once you've given it, let's say you've given it to a member of the public, then now a member of the public has it and they're going to do with it what they want. So it doesn't change the classification of it at the end at the employing entity. So it would still be private under 1343, and I would redact those.
All right, I'll do a last call for questions here. And then we're going to go ahead and close up the webinar. So if you have a question, please feel free to put it in the Q&A now. Let's give another minute for that. Okay, I'm not seeing any. If you think of questions later, please feel free to email us or give us a call, and we'll be happy to address those questions that you have. Thanks for attending the webinar series, and this webinar video will be on YouTube within a day or two, and the other webinars are already up on our YouTube.